Confidentiality. Rule 1.6 sets forth the attorney's ethical obligation of confidentiality. The first thing to know is what the obligation covers. It covers everything the lawyer learns as a result of her representation of the client. Everything the client tells the attorney, everything the attorney learns about the client's matter as she investigates the case, any information which the attorney possesses related to the representation is covered by the attorney's obligation to maintain confidentiality. Comment 2 sets forth the rationale behind attorney-client confidentiality. A fundamental principle in the client-lawyer relationship is that the lawyer must not reveal information related to the representation. This contributes to the trust that is the hallmark of the client-lawyer relationship. The client is thereby encouraged to seek legal assistance and to communicate fully and frankly with the lawyer, even as to embarrassing or legally damaging subject matter. The lawyer needs this information to represent the client effectively and, if necessary, to advise the client to refrain from wrongful conduct. The ethical obligation of confidentiality is different from privilege, which is a part of the law of evidence. As Comment 3 explains, attorney-client privilege and the work product doctrine apply in judicial proceedings in which the lawyer may be called as a witness or otherwise required to produce evidence concerning a client. As compared to confidentiality, only certain things are privileged. For example, private attorney-client communications for the purpose of obtaining legal advice are privileged. The attorney cannot be forced to disclose the content of the communication and should, on the client's behalf, assert the privilege if called to testify. There are certain exceptions to the attorney-client privilege. One relevant exception is the crime-fraud exception. If the attorney-client conversation was held to aid in an ongoing or future crime or fraud, the conversation is not privileged. The following conditions must exist for the crime-fraud exception to apply. 1. The client must have an intent to commit a crime or fraud, whether the lawyer knows of this intent or not. 2. The conversation must be in furtherance of the crime or fraud. And 3. The party attempting to pierce the privilege has the burden of proving the crime-fraud exception. This is a high burden because we want clients to be able to consult with their lawyers about their plans, and society hopes the lawyers will dissuade the clients from carrying out activities that are criminal or fraudulent. There are also ways in which the attorney-client privilege may be waived. For example, if the attorney-client communication is in the presence of a third party, the privilege is waived. The privilege is also waived if the client and the lawyer fail to assert the privilege, or if the client consents to disclosure, or if the client discloses the communication to unprivileged third parties. You will learn more about attorney-client privilege in evidence class. However, for this class, it is important to note that none of these exceptions to privilege or waiver of privilege change the lawyer's obligation of confidentiality. Thus, if the client's friend sits in on an attorney-client conference, the friend could be subpoenaed and asked what the client said. However, the lawyer would still have the obligation to keep confidential what she learned, even if the attorney-client conference was not private. It is most important to remember that confidentiality is much broader than privilege. As Comment 3 concludes, the confidentiality rule applies not only to matters communicated in confidence by the client, but also to all information relating to the representation, whatever its source. There are limited exceptions to a lawyer's duty to maintain confidentiality. First, the client may expressly or impliedly waive confidentiality. The client may give informed consent, after counseling, for the lawyer to share confidential information. For example, the client who wants his attorney to negotiate a particular outcome may explicitly say that the lawyer is permitted to share certain material facts with the opposing party in order to negotiate on the client's behalf. Similarly, the client may have impliedly given the attorney permission to share the facts that would be relevant and necessary to negotiate the matter. Rule 1.6b explicitly states that the lawyer may reveal otherwise confidential matters, quote, to the extent the lawyer reasonably believes necessary under certain limited set of circumstances. One circumstance is to prevent reasonably certain death or substantial bodily harm. For example, if the client credibly tells his attorney that he is going to kill his estranged wife when he is released from jail, this exception would permit the lawyer to take protective action. This exception recognizes the overriding value of life and physical integrity and permits disclosure reasonably necessary to prevent certain death or substantial bodily harm. See Comment 6. Can you think of other scenarios in which the lawyer may want to reveal confidential information to, quote, prevent reasonably certain death or substantial bodily harm, close quote? Note, however, that this is permissive. The lawyer may reveal. The rules of professional conduct do not require the lawyer to turn his client in. Other law may do that. For example, child abuse reporting statutes may require anyone having reason to know a child is abused to report that to the Child Protective Services. Comment 12 notes that while other law may require an attorney to disclose information about her client, whether that other law supersedes Rule 1.6 is a question of law beyond the scope of these rules. The scope note states that, quote, the rules presuppose a larger legal context shaping the lawyer's role, and that context includes substantive and procedural law in general. Thus, a lawyer may have a statutory requirement to report on his client, but this question must be answered after researching that law. It is not answered by the rules. A second exception to confidentiality is to prevent the client from committing a crime or fraud that is reasonably certain to result in substantial injury to the financial interest or property of another, where the client is using or has used the attorney's services to carry forth the crime or fraud. The lawyer is permitted to blow the whistle on his client here because his services have been used in furtherance of the crime or fraud. As Comment 7 notes, such a serious abuse of the lawyer-client relationship forfeits the protection of this rule. This comment also references Rule 1.2d, which prohibits the lawyer from assisting in a client's crime or fraud, and Rule 1.16, which requires or permits the lawyer to withdraw from representing the client. Thus, the lawyer who discovers his client is using his services to commit a crime or fraud has all three things to think about: whether to blow the whistle on his client, how to avoid becoming implicated in the crime himself, and whether he needs to or should withdraw from further representation. The third exception is related. Again, where the client has used the lawyer's services in furtherance of a crime or fraud, and the lawyer may still prevent, mitigate, or rectify substantial injury to the financial interests or property of another that are reasonably certain to occur, the lawyer may breach confidentiality to do so. This exception applies when the lawyer does not learn about the crime or fraud until after it has occurred. It applies when the loss can still be prevented, mitigated, or rectified. Here again, this is permissive. A lawyer may choose to do this or may choose not to. Other law may exist that could require the lawyer to blow the whistle on the client where the lawyer's services have been used by the client to perpetrate a crime or fraud. Note that these exceptions in Rule 1.6b 1 through 3 do not permit the lawyer to reveal the client's confessions to a past crime or fraud. Instead, their focus is on preventing the crime or preventing, mitigating, or rectifying the injury when there is still time to do so. These rules do not apply when the client hires the lawyer to represent him concerning his past crime or fraud. A fourth exception to the obligation of confidentiality is to secure legal advice about the lawyer's compliance with these rules. This will certainly be relevant in any of the prior scenarios, where the lawyer realizes that his client is about to commit a crime or is using his services to commit fraud. In such cases, the lawyer would be justified in getting advice from an expert in legal ethics. But this exception may be relevant in other scenarios where the lawyer needs advice about his obligations under the rules. The fifth exception covers a variety of situations in which the attorney and client may have different interests. If there is a legal or disciplinary case charging the attorney with complicity in the client's wrongful conduct, the lawyer may, to the extent reasonably necessary, reveal confidential information to defend herself. If there is a controversy between the lawyer and client, the lawyer may reveal confidential information to defend himself. This would arise if the client sues the lawyer for malpractice or if the criminal defendant client asserts ineffective assistance of counsel. Finally, if the client has failed to pay his fee and the attorney sues the client to collect the fee, the attorney is permitted to prove the services rendered in order to collect the fee. The sixth exception permits disclosure to comply with other law or a court order. As we have already discussed, other substantive laws such as child abuse reporting statutes may require an attorney to disclose information about a client. This subsection of Rule 1.6 permits this disclosure if that other substantive law requires it. Similarly, a lawyer may be subpoenaed to testify about his client. Here, Comment 13 advises that the lawyer should, on behalf of the client, assert all non-frivolous claims that disclosure is not required or that the information is protected by the attorney-client privilege or other law. If the court orders the attorney to testify, the attorney must consult with his client about a possible appeal. However, unless the client decides to appeal, this section of the rule permits the lawyer to comply with the court's order. Comment 14 notes that the lawyer may disclose confidential information only to the extent the lawyer reasonably believes necessary to accomplish one of the purposes specified in this rule. Of course, the attorney should always fully counsel the client and try to dissuade the client from taking any action that would be criminal or fraudulent. As Rule 1.4a5 and Rule 1.2d both require, the lawyer must consult with the client about the limitation on the lawyer's own conduct. This would include telling the client what the lawyer will do if the client persists in pursuing a criminal or fraudulent course of action. But in any event, disclosure of confidential information adverse to the client's interest should not be greater than the lawyer reasonably believes necessary to accomplish the purpose, according to Comment 14. If the disclosure is made in a judicial proceeding, for example, if the lawyer is subpoenaed and then ordered to testify about the representation, the disclosure should be limited to the tribunal or other persons having a need to know. Finally, a few highlights about practically working with client confidentiality. What is permitted when a new solo practitioner wishes to consult with a more senior attorney in order to be competent? Comment 4 is instructive. The use of a hypothetical to discuss issues relating to the representation is permissible so long as there is no reasonable likelihood that the listener will be able to ascertain the identity of the client or the situation involved. It is possible to obtain advice by eliminating any facts that will identify the particular client or situation. Of course, in the case of a solo practitioner seeking guidance, there is always the possibility of asking the client for informed consent to share the information with a particular mentor. Would this standard, limiting information so that the client and the matter are not identifiable, be relevant for a law student writing a reflective paper in order to learn the most about his experiences? Attorneys must also take steps to protect confidentiality. As Comment 16 advises, act competently to safeguard information against inadvertent disclosure. Should you leave your case file in opposing counsel's conference room while you take a lunch break? On counsel table in the courtroom? Should you discuss a client matter in a public place, an elevator, a restroom, a restaurant? Comment 17 advises that when transmitting a communication on a client's matter, the attorney must take reasonable precautions to prevent the information from coming into the hands of unintended recipients. The comment further notes that an attorney and client could contract for special security measures. Presumably, what are reasonable precautions may change as technology changes over time. This concludes the unit on confidentiality. We will be discussing the problems posted on TWEN during class.